Hey gang, welcome back to the channel. Today we're going to be talking about the 6 ways you may be wasting a lot of money on your trademarks, and that is money you are not getting back. Ready? Let's do this. Hey gang, if you're new here, my name is Jim. I am a trademark lawyer and a YouTube entrepreneur. On this channel, we explore the practical tips, tools, and legal strategies you can use to start, build, grow, and of course, legally protect your own online business. And today we're going to be talking about how people waste a lot of money on trademarks. And I realize that as a trademark lawyer, I shouldn't be telling you that people waste a lot of money on trademarks, but if you stick with me, I think you'll see where I'm going with this. Now, as an online entrepreneur, your brand is everything. And you should be doing, and you probably want to be doing, everything possible to legally protect and claim the naming rights to that brand you have online. But you also don't want to be in a situation where you're overpaying for a lawyer for services that maybe you don't even need. So for that reason, maybe you find yourself in a situation where you head on over to the USPTO website and you find the application to file a trademark and you think, well, this looks easy enough, I can do this. And so you try and fill out the application on your own, or you go to one of those filing services, and I'm not going to name names here, but you know who I'm talking about, where they will take all that same information that you are just going to put into the application, and they will then go ahead and, for a small fee, file the application for you. And I might add, they do this without, one, scrutinizing your application to make sure that the information that you're entering is actually legally correct for what you need in terms of protecting your trademark, and two, they don't do a trademark search to make sure that the name that you're trying to use is not already taken or is not deceptively close to a name that's already taken. What could go wrong with using one of those services or DIYing it? Unfortunately, most entrepreneurs who are trying to DIY it or use one of these filing services just don't properly understand all of the legal pitfalls that come with using one of these services or trying to do this process on your own. It is a legal process. Filing a trademark application is a legal process, and as such, it would be appropriate to have a lawyer look through your application. But since you're choosing not to have a lawyer look through your application, then I prepared this video for you here today where I'm going to tell you what I would be looking at if I were looking at your application. Because the last thing I want for you is to have your application get opposed, canceled, or even invalidated because you entered some information incorrectly at the beginning. And in addition, I don't want to see you in a situation where at the end of the day, in 8 months or 12 months from now, when you normally would be getting a trademark registration if you filed today, you find yourself with no legal rights and no protections for the name that you've chosen for your brand. That's a bad situation, that's a bad place to be in, and I don't want that for you. Fair enough? All right, let's jump to the 6 mistakes that I see people make, but before I do that, I do have one little caveat I want to make. And that caveat is basically the exception to the rule. Now, I know you probably have some friends in a Facebook community or maybe some other business partners that you're working with who say, you know what, I've used one of those filing services and I got my trademark and no problems. My trademark went through, it got registered, and I've never had an issue. Let me tell you, that is the exception, that is not the rule. That does happen from time to time, but at the end of the day, it is a gamble and there's no guarantees that they are going to get you your trademark if it's not done the right way and if your application is not properly scrutinized. So let me give you 6 things that you should be looking out for when you're filing your application to make sure that even if you do decide to use one of these services, that you're putting yourself in the best possible situation so that your trademark is not invalidated and you actually have the best chances to have your trademark succeed for you. And actually, I'm going to add a bonus at the end because I just thought of one more mistake that I see a lot of people make, but I'm going to add that at the end here, so stick with me. The first mistake I see people make, and I've talked about this on prior videos, is they don't list the proper owner on the application form. And this can happen in one of 2 ways. The first way this can happen is, let's say you're ready to file your trademark application, so you go online or you go to one of the filing services and you think, well, I'm the one that owns the trademark, so I'm going to list my name as the name of the trademark. And by my name being like me personally, my name, that's what I'm listing on the application. And that's all well and good. But what happens is you may start off with yourself as the name, but technically you're a sole proprietor. So if you don't list yourself as sole proprietor, that's problem number one. Problem number two is it usually takes between 8 to 12 months or longer to get a trademark registered through the USPTO. It's actually taking about 8 months for applications to get looked at by the USPTO office right now. So in that 8 to 12 to 16 months between now when you file your application and when your trademark actually registers, chances are your business is going to be doing better, you're going to be making some sales, things are going to be going well, and then at that point you may decide to go ahead and file for your LLC. And what will happen is by the time your trademark registers, it's not you individually that is using the mark or you as a sole proprietor that is using the mark. It's actually the LLC that is using the mark. And if there's not a sync between the entity that's using the mark and what is listed on the trademark registration, then that is a problem, and that basically says you as an individual are not using the mark. And so because you're not using the mark is invalid. And so that would be grounds for somebody to bring a cancellation proceeding if they wanted to. So if somebody was looking up your mark and they really liked your name and they see that you as a sole proprietor are using it, but then they go to your website and they see that it's your LLC that's actually using the mark, they could bring a petition to cancel your mark at that point. So that can be a problem. The second way this could become a problem is if you form an LLC before you file your trademark application, but at the time that you file your trademark application, you list again yourself as the owner and not the LLC. And if you do that, then the application is void from the very beginning. And yes, there's some other attorneys out there, they've commented on my videos in the past, they would say, hey, just file an assignment, no biggie, just no problem. But yes, an assignment costs money, and it costs attorney time to draft that. And also the rules technically say that if your LLC was in force at the time that you filed the application, the LLC was what was actually using the mark, but you listed yourself as the owner who was using the mark, your application is technically void from the beginning and all those fees you paid are non-refundable. So that can be a problem. So you need to make sure you list the proper owner, and if you change it later on because you form an LLC, you need to make sure that you file that assignment so that it changes who the ownership of the trademark is on the official record with the USPTO. The second issue that I see on a lot of trademark applications is people who use the wrong date of first use. So you actually have to list on your application the date that you first used the mark in commerce. If you're not using the mark in commerce currently, then you can file what's called an intent to use application, and then you can file a statement of use later on if you start using the mark in commerce. But what a lot of people will do is they will list something like the date that they got their website, the date that they formed their LLC, and different things like that. And none of those are correct. The actual date is the date that you started using your mark in commerce. It's the date you started selling something under the mark that you're applying for. And so a lot of people mess this up. And while it's not, I wouldn't say in terms of the issues that come up, it's the biggest issue. It is definitely an issue. And if you ever get into federal court, which is highly unlikely, I will add, if you ever get into federal court and there's somebody trying to cancel your trademark for some reason, or they're trying to oppose your trademark because they're saying, well, you're not really using it because the date that you use is not the date that you're actually using it, then it can come up, it can become an issue, and you don't want that to happen. So you need to make sure that the date you put on your application is the proper date that you actually started using the mark in commerce. And if you're confused by what that means, you really should probably talk to a lawyer to make sure you get it right. Third thing is, and this is a pretty big one, is using the wrong goods or services on your application. So when you file your trademark application, you also have to tell the USPTO what goods or services you're actually selling the mark under. And so there's 45 different categories of goods and services that you might be able to fall under. And what can happen is when you file your application, you want to make sure that your description is not too broad but not too specific. And what do I mean by that? Well, you can narrow down the scope of your goods and services after you file your application. You cannot make it more broad. If you want to make it more broad, you have to file a second trademark application to include additional services or goods at that time. So when you file your application, you need to make sure that anything that you're currently selling, you want to make sure that's included. And anything that you intend to sell in the future, you could also include that, or you could file a separate application later on. To save on legal fees, if you're hiring a lawyer, then it's better to include it all in this initial application. And so you need to make sure you've covered all the different classes that you might be selling in. So when I work with clients, I ask them to provide me a description of everything that they're selling. And I will go through the trademark manual and look and try and identify each and every class of goods or services that my clients might be selling under. So if you are selling, let's say, supplements, and you want to make sure that you've got all the supplements that you're listing under your brand, you want to cover those. Those might all be in one class. But I heard another lawyer talk about this where she had a client who had filed for, let's say, all the different types of supplements they were selling, but they didn't actually file for a supplement store, which is a service, versus the goods themselves. And so they actually had created an online store that was selling supplements, and they forgot to register for online store. They only registered for the supplements they were selling. And that became a problem when somebody else came in and tried to register the name that they were using for the online store. And then that becomes a situation that you really don't want to be in. So you want to make sure you cover all the proper classes of goods or services that you're selling under. And if you miss one, that can be a problem later on. Again, this is one of the reasons why you might want to talk to a lawyer to make sure you're not missing any classes of goods or services on your application. The fourth problem area that we see is people use the wrong specimen. And I see this all the time because when I am preparing trademark applications for clients, I'll ask them to provide me with a specimen. Now, 9 times out of 10, I end up just going to their website, snapping a screenshot of what I know the appropriate specimen should be, and using that in the application. Because when I ask clients to submit the specimen, oftentimes they'll just send me a copy of their trademark. And I can tell you that this is a problem that I see over and over again because when I'm doing applications, I'm constantly looking at other related trademarks, and I'm constantly clicking in to look at all the filings for that trademark. You can actually do that. And I can't tell you how many times I've seen somebody who uses a filing service that we've talked about at the beginning, and they file something and they send a specimen into that filing service, who then uses the specimen that the person gives them without actually looking at the specimen to see if it's an appropriate specimen. And then the filing gets rejected because of an improper specimen. And at that point, rather than spend additional money or try and figure out what they can do to fix the problem, the client gets confused, they get frustrated, and they just abandon the trademark application altogether. I've seen this numerous times. It is a huge problem. So you need to make sure you get the right specimen. And again, if you don't know what a specimen should look like, I probably should do another video on that. But you can obviously talk to a lawyer and they can help you. There's also some really great, helpful, informative videos on the USPTO website that talk about what a specimen should look like. So you want to make sure you get that right. If it's wrong, then your trademark application will get denied. Now, you can overcome that denial, but you need to know how to do that to submit a proper specimen. Number 5, the big 5, that you need to understand, your trademark is only valid as long as you use it. And so a lot of people will take all the steps necessary to register and protect their name, and they do that, and then they stop, basically operating their business. Or they change the name of their business, or they register a logo thinking, oh, I want to register this logo because it looks really cool, but then they change their logo. That registration that's now collecting dust that you're no longer using is no longer valid. So trademarks can continue in perpetuity if you continue to pay the filing fees every 5 to 10 years and you continue to use a mark. But if you stop using the mark, the trademark is no longer valid. And that is a problem that you don't want to get yourself into. So, I mean, if you're going out of business, that's one thing. The trademark's going to be invalid. But if you want to continue to use that trademark, then you need to continue to use that trademark, if that makes sense. That sounded kind of stupid, but you get what I'm saying. You got to use it or lose it, basically, with the trademark world. So the other thing that you need to be aware of, and this is reason number 6, is that you must continue to monitor and enforce your trademark to make sure it's not diluted by other marks in the marketplace. This will happen automatically. If somebody tries to register a mark that's similar to yours, then the USPTO, the trademark attorneys there, will in all likelihood, they will deny a mark that's too similar to yours for likelihood of confusion. But if a mark gets past that step and gets all the way to the publication stage, you need to monitor and make sure there's not something that you think is too similar to you. So if something comes through and does get to publication, if you're monitoring the trademark database, because this is something that got past the examining attorney, then you can file a notice of opposition to make sure that mark doesn't register. Or alternatively, you need to be looking common law, all the Google searches and on the yellow pages and on Amazon and on TikTok and Instagram and all these places to see if anybody else is trying to use your mark. And if they are, you can send them cease and desist letters to tell them to stop because your mark is already registered. And so you need to enforce your mark, and this is something that has to happen after your mark is already registered. If you don't do that and there's too many people that come into the marketplace and use a mark that is the same or similar to yours, then it's basically diluting your mark, and your trademark could ultimately get canceled for that reason, because there's too many other names like yours in the marketplace, because it's no longer unique. It no longer shows the source of your goods or services that you're offering. So that's something you need to be aware of. You need to continually be monitoring and enforcing your trademark. You need to be continually monitoring and enforcing your trademark to make sure it remains valid. All right, last bonus tip here, and this is especially important for those of you that are trying to DIY it or are trying to use a service. A lot of times these services do not use, or these filing services do not use a comprehensive trademark search. They might do a knockout search, and a knockout search is basically where you take the name that you're planning on using and you go to the USPTO database and you basically type in the name and see if something pops up. And 99 times out of 100, nothing is going to pop up. And so those searches are going to come back favorable. The problem with that is it's not typically the exact name search you're worried about. It's the near exact name search, or the phonetic equivalent name search, or the different spelling variations name search, where you might run into problems, and you need to do a comprehensive name search. You also need to do a comprehensive common law search through Google and Amazon, all those places I listed before, to make sure nobody else is using your name or a name that's deceptively similar to one that you're already using. So this is where a lot of people make this mistake, is they don't do that comprehensive search. Now, there are some exceptions. I've seen people do this where they filed a trademark application for a name they've been using for years and years and years. They know that they are the established leader in that industry. They know that pretty much nobody else is using it. Maybe they've done their own search and they know that nobody is using that name, and they know they're not infringing on anybody, and they're an established business. In those cases, it is possible to file an application without doing a comprehensive search that an attorney would do for you. But I would say those situations are rare, and you typically are going to want to have an attorney do a comprehensive name search and make sure that your name is not likely to be confused with an existing name, or that you're not infringing on another name. So if you're interested in filing for trademark protection for your name, and you would like to have an attorney talk to you about what it is that you're doing and make sure that you're doing the application properly, I am willing to do a free 30-minute call with you to go over your options and let you know what it takes to, if you're interested in hiring a lawyer, what it looks like to hire our firm, or if you want to do it yourself, kind of walk you through the process to make sure you're not making any mistakes. I'll include a link down in the description below to go ahead and schedule that call if that's something you're interested in. But if you're interested in learning more about trademarks, I've done another video right here above the cat that will walk you through some of the other issues that you need to be thinking about when it comes to trademarking your brand. Thank you so much for watching today, folks, and we'll see you in the next video. Take care.